Welcome to the Deep Dive, your shortcut to being well-informed. Today we're really getting into the weeds on software patent law, specifically its origin story. We're looking at this fundamental tension. If you come up with a brilliant new calculation, a mathematical formula, can you actually own it just because you use it in, say, a factory setting? When does an abstract idea cross the line and become a concrete patentable process? If you're looking for the case that really tried to draw that line, you have to look at Parker v. Flook. It's a 1978 Supreme Court decision, absolutely foundational. Our mission today is to unpack why the court made the call it did and what that really means for basically all the software that's been written since then.
Yeah, this one's a landmark case in intellectual property law, no doubt. The official citation for those keeping score is Parker, Acting Commissioner of Patents and Trademarks v. Flook. It's case number 77642, decided by the U.S. Supreme Court, June 22, 1978. And it came to them on certiorari from the Court of Customs and Patent Appeals, the CCPA. That's the court that eventually became the Federal Circuit, which handles patent appeals now.
Right. And who are the key players here? You had the inventor, Flook.
Correct. Flook was the respondent, represented by D. Dennis Algaretti. Arguing against him was the petitioner, Acting Commissioner Parker, representing the Patent Office. Their case was presented by Deputy Solicitor General Wallace.
And on the bench.
The opinion for the court, the majority opinion, was written by Justice Stevens. And there was a significant dissent written by Justice Stewart.
Okay, let's get into the invention itself. What exactly was Flook trying to patent? It wasn't a new machine or chemical, right?
No, not at all. He was seeking a patent for a method for updating alarm limits. Think about big industrial processes like oil refining, catalytic conversion, that sort of thing. In these plants, you constantly have to monitor variables, temperature, pressure, flow rate, and if one of those variables goes outside a safe or efficient range, an alarm goes off. That preset threshold is the alarm limit.
Okay, standard stuff. So what was Flook's contribution? Well, normally those alarm limits are kind of static. Flook realized that sometimes, especially during unstable periods, like starting up the plant, you need those limits to change dynamically. So his method had 3 steps. First, you measure the variable, like temperature, standard. Third, you use that calculated baseline to set the actual alarm limit, also pretty standard. But the second step, that was Flook's novel part, using a specific mathematical formula, his algorithm, to calculate a new alarm baseline on the fly.
Ah, okay. So the overall process measure, calculate, set alarm wasn't new.
Exactly.
He just swapped out the calculation step with his own new formula.
Precisely. And it's important, his patent application didn't really describe any new hardware or chemical processes. The novelty was purely in the math, the algorithm, designed to be used by a computer for automatic adjustment.
So the facts really boil down to known industrial process, known components, but a new mathematical formula plugged into the middle.
That's a perfect summary. And that leads straight to the legal question the Supreme Court had to tackle. Basically, does identifying a useful but otherwise conventional industrial application for a new mathematical formula make the whole method patentable under Section 101 of the Patent Act?
And Section 101, just to remind everyone, is that first hurdle.
Yeah.
It defines what kinds of things can even be patented, processes, machines, and so on. It's about eligibility, right? Before you even ask if it's new or non-obvious.
Exactly right. It's the gatekeeper. And the Patent Office, through Commissioner Parker, slammed the gate shut. Their argument was pretty straightforward. The only new thing here is the formula. And under the existing precedent, Gottschalk v. Benson, mathematical formulas by themselves are just not patentable subject matter.
Okay, makes sense from a legal precedent standpoint. Was there also a policy argument? Were they worried about something bigger?
Oh, definitely. Parker argued that allowing this patent would basically break the system. Imagine every time someone developed a new algorithm for, I don't know, optimizing inventory or something and just applied it using standard computers. They get a patent. The commissioner feared this would stifle the growing software industry and swamp the Patent Office.
Right, the floodgates argument. So Flook needed to argue his invention wasn't just the math. How did he try to do that?
He tried to emphasize the context and application. First, he said, look, my claim is limited. It's specifically for the petrochemical industry. Second, and this was key to his argument, he pointed to the post-solution activity.
Meaning the final step, adjusting the alarm.
Yes, that physical step of actually changing the alarm limit setting. He argued this distinguished his claim from Benson, where the algorithm basically just produced a number. He wasn't trying to patent the formula in the abstract, just its use in this specific physical process.
Okay, so we have the arguments laid out, which brings us to the decision. The Supreme Court sided with Parker, right? Flook's method was unpatentable.
That's correct. They reversed the CCPA. No patent for Flook.
Now let's really dig into the why. The court's reasoning here is crucial. It sets the stage for decades of software patent battles.
Absolutely. The court started by reaffirming that core principle. Mathematical formulas, laws of nature, abstract ideas, these are the basic tools of scientific and technological work. They belong in the public domain. You can't patent Imn-Si-Ha or, the Pythagorean theorem. Granting patents on these fundamental truths would block innovation, not promote it.
But Flook wasn't claiming the formula in isolation. He was claiming the whole process, including applying the formula to set the alarm. How did the court deal with that application part?
They tackled it head-on. They basically said that adding insignificant post-solution activity steps that are already well-known or obvious doesn't magically transform an unpatentable principle into a patentable process. Justice Stevens called it elevating form over substance. His analogy was spot on. You can't patent the Pythagorean theorem simply by adding a final step like apply the theorem to survey land using conventional methods. The inventiveness has to be in the application itself, not just in tacking a known process onto a newly discovered principle.
Okay, that makes sense. And this led them to the really critical analytical tool, the one everyone talks about from this case, the prior art test. which they drew from an older case, O'Reilly v. Morse.
Exactly. This test is the core of Flook's reasoning for algorithm claims. The court said, okay, when you're looking at a claim under Section 101 that involves a mathematical formula, you have to assess its eligibility by treating the mathematical formula as if it were already known, as if it were part of the prior art. You ignore its novelty for the purpose of the Section 101 analysis.
Wait, hold on. You have to pretend the only inventive part of Flook's claim is actually old news. How is anything left to be patentable then? That feels inherently problematic.
It is the controversial part, and the dissent certainly felt it was problematic, but the majority's logic was that the type of discovery, is it an abstract idea or a concrete application, needs to be assessed first, before you get to novelty under Section 102 or non-obviousness under Section 103. So once you hypothetically treat Flook's new formula as well-known, what's left of his claimed process?
Well, you're left with measuring a variable using some calculation, which we now pretend is old, and setting an alarm limit using a computer.
Right, and were those steps taken together inventive in 1978?
No, probably not. That sounds like standard industrial automation.
Exactly. The court concluded that once the formula's novelty was mentally subtracted, the remaining steps were entirely conventional. Therefore, the application, viewed as a whole, under this specific test, contained no patentable invention. It was just an improved method of calculation tied to a specific end use, and that's not eligible subject matter under Section 101.
Okay, I see the logic, even if it feels like a bit of a legal maneuver. What specific precedents did they lean on to justify this approach?
Well, O'Reilly v. Morse gave them the methodology, the treat the principle as known approach. Gottschalk v. Benson, of course, was key for establishing that algorithms themselves are abstract and unpatentable. And they also cited Funk Bros, Seedcom v. Caloco, another classic case, which reinforced the idea that the invention has to be in the application of the law of nature to a new and useful end, not just finding the law.
Now, you mentioned a dissent earlier, led by Justice Stewart. They obviously didn't agree with this treat the formula as prior art step. What was their main objection?
Their core argument was that the majority was improperly mixing up the different sections of the Patent Act. Justice Stewart basically said the majority imported the tests for novelty, Section 102, and non-obviousness, Section 103, into the initial subject matter eligibility analysis, Section 101. He argued Flook's claim described a process, a series of steps acting on physical variables to achieve a result. Under the plain language of Section 101, it should have been eligible subject matter.
So the dissenters felt the eligibility question should be simpler. Is it a process, machine, etc.? Yes. Okay, then move on to ask if it's new and non-obvious.
Precisely. They felt Flook's claim, even with the formula, was a process just like other patented processes that incorporate laws of nature, like using gravity in a paper-making machine, which was upheld in the IPAK process case they cited. They argued the majority's approach effectively denied patentability based on lack of novelty, but did it under the guise of Section 101 eligibility, a procedural shortcut, essentially.
That's a really fundamental disagreement on how patent examination should work. So the majority says filter out the abstract idea first. The dissent says look at the whole process for eligibility first.
That's the heart of it. And while the dissent's view has had its moments in later debates, the Flook majority's approach, particularly that treat the formula as prior art test, became incredibly influential, especially as software became more complex.
Which brings us to the impact. Fast forward to today. What's the lasting significance of Parker v. Flook?
Its main legacy is establishing that specific test for algorithm-based inventions. Assume the math is known, then look for an inventive concept in the application itself. If the application just involves generic computer implementation or conventional steps, the claim likely fails under Section 101. This principle was heavily reinforced and refined by later cases, most notably Alice Corr v. CLS Bank. Flook was really the first major speed bump for software patents.
And what about that point about Congress?
That's also hugely significant. The court explicitly stated that extending patent protection to something like computer programming, which they felt was totally unforeseen when the Patent Act was written in 1952, should be a job for Congress, not the courts. They basically punted the broader policy question about how best to protect software innovation, suggesting Congress needed to create specific rules if it wanted to.
Which, arguably, Congress still hasn't fully done in a comprehensive way, leading to decades of court battles trying to apply these old principles to new tech.
Exactly. That deference has shaped the entire landscape. For a long time, inventors had to carefully frame their software inventions as being tied to specific machines or physical transformations to try and get around Flook and Benson.
Okay, let's boil it down. If someone listening needs the one key takeaway from Parker v. Flook, the elevator pitch, what is it?
The most important takeaway is this. Simply finding a new mathematical formula and applying it to a known industrial process using conventional steps isn't enough to get a patent under Section 101. The inventiveness needs to be in more than just the calculation itself. The overall application, stripped of the formula's novelty, needs to represent a patentable contribution. You can't just patent the math dressed up in old clothes.
So we've seen how the Supreme Court, through this prior art test, drew a firm line, and maybe a controversial one, but a firm one between unpatentable abstract math and patentable technological processes.
Right. And it leaves us, and you listening, with a really interesting question today, doesn't it? Now that software, AI, complex algorithms are deeply embedded in almost every industry driving innovation, was the 1978 court right to defer to Congress? Or is it time for the legislature to finally step in and provide clearer rules? Or perhaps is that core principle that fundamental mathematical truth should remain free for everyone to use still the right foundation, even in the age of AI?
Definitely something to think about. Thanks for joining us for this deep dive into Parker v. Flook. We hope you'll continue exploring these fascinating intersections of law, technology, and innovation.
Thanks for tuning in to the full episode. If there's any topic or case law you'd like us to cover next, share your suggestion in the comments on our latest video. And if you found value in the podcast, don't forget to like, subscribe, and hit the bell icon to stay updated.